The following program is suitable for general audience of any age.
Tonight, we speak on the complexities relating to rent in Sri Lanka. What legislation governs this area and how do recent developments aim to prevent lapses? A very good evening and thank you for joining us on yet another episode of Law, Land and Liberty, where we bring to you key legal concepts and break it down for the layman. Today's topic is something that we have briefly touched on in the past, but we haven't been able to get into in depth. And considering the current context and the developments surrounding it, it's very much timely that we do so. And that's on the Rent Act and specifically on renting and occupants. To speak about this, we have someone that is not a new face on the program, but it has been quite some time since we've been able to welcome him back. It's an absolute pleasure to have you, Mr. Kamran, Aziz, attorney at law. Thank you so much, sir, for coming to the program today to actually help us understand this topic of rent and the Rent Act.
Thank you, Anuradhi. Good to be back. Thank you for having me.
Yes, absolutely lovely. So before we go into any of the specifics of the discussion, we're going to be first breaching into the fundamentals. Next, we'll be getting into the current contextual realities, how we can understand it from a tenant's perspective. And finally, we'll be getting into what we can expect with the recently introduced Protection of Occupants Bill as well.
Hello, my name is Derana. I am a student. My question is on fundamentals. What laws govern rent in Sri Lanka? Thank you.
All right, well, without any further ado, let's get right into this discussion. Thank you very much once again, sir, for volunteering to help us understand this very vast topic. I understand that with the current context as well, there's been quite a few developments and it's essential that we get some grasp of understanding relating to it. Before we get to the specifics relating to what's happening right now, I think it's important for us to understand the impact of what the Rent Act does to Sri Lanka's legislature. Why did we need the Rent Act and what is its significance, sir?
Yes. So, if we go back 56 years ago, 54 years rather, that was when the Rent Act was incorporated into our law, 1972. That was essentially due to the sweeping victory that Madam Sirimawa Bandaranayake, when she won the polls in 1970. She won on a platform of socialism and populism. And because of that, Housing Minister at that time, Mr. Peter Kenneman, who was the brainchild of the Rent Act, brought this into play, and it was incorporated in 1972. Now that's the background as to why, because she came on a sweeping mandate of socialism and populism, and because of that, the government felt that they had to do something for the people. So it was not only the Rent Act. There were other forms of law that was also brought in during this time. The land reform law, if you can remember, in 1972, a lot of tea estates were nationalized, and that was to even the playing field. Then the Industrial Disputes Act, which from the point of its incorporation and in becoming law, provided substantial protection to employees in respect of their status in work and hiring and firing. So it made it firing employees much harder. That you had to hold inquiries and so on and so forth. Then, of course, there was also the ceiling on housing property, where at that time owners were limited in owning property as well. So these were all socialist agendas of the then government, and at that time the government thought it was a requirement, as due to the fact that premises that were given on lease were very, very scarce. So there were very few, far in between. So they thought it fit that tenants should be protected during that time, and that is why the Rent Act came into operation at that time. Now the Rent Act itself at that time I think was a good law at that time. But we have come a long way from that. It's 54 years since the incorporation of the Rent Act, and so much has taken place after that. Now the Rent Act stipulates two kinds of premises. One is residence and one is business. So let's start with that. So it says residential premises let before the 1st of January 1980 are governed under the Rent Act. So any residential premises let by the landlord to a tenant before the 1st of January 1980 is deemed to be a premises that is governed under the Rent Act. And also business premises which do not come under the exception rule are also governed under the Rent Act. So that's basically essentially a very narrow way of looking at it, the Rent Act. But there are so many other provisions that stipulate how the Rent Act and the parties are governed by it.
Yes, I think that's a perfect segue for us to get into the specifics as well. So now, as you mentioned, there's distinctively instances where the Rent Act would apply. Can you help us further understand exactly when the Rent Act applies and what its salient features are with your understanding?
Right, okay. So if you Section 2, subsection 4 of the Rent Act, A, stipulates that accepted premises don't come under the Rent Act. Now, accepted premises are defined under Section 5, which says that business premises which are valued as an annual value, if it goes beyond that annual value, they come under accepted premises, and then they don't fall under the regulations under the Rent Act. So that's number one. But that's only concerning business premises. Like I said earlier, residential premises which were let before the 1st of January 1980 come under the Rent Act. So those are the kind of premises that are governed under the Rent Act. Now, for example, if there was a premises that were residential and you built it after 1980, or you as an owner you were living in the premises in 1980 or up to 1985 and you rented after that, then those premises are not governed under the Rent Act. So those are the exceptions. So when premises are accepted, they don't fall under the provisions of the Rent Act, whereas all the other premises fall under the provisions of the Rent Act, governed under the Rent Act.
Yes. Now getting into the technical aspect of the Rent Act in itself, specifically when the Act mentions standard rent, yes, and also limitations on rent. Can you help us understand the mechanism behind that? What exactly has the law set out?
Right, okay. So this Rent Act is a very technical piece of legislation. There is the standard rent, the authorized rent. There are several sections in the Rent Act which stipulate these kinds of. So the annual value. So all these are determined in terms of the annual value. So there's a standard rent which you can levy to a certain premises, and you can't increase that unless it's provided for in the Act. Now, for example, if the landlord wants to increase the rent, he can't arbitrarily inform the tenant that I want to increase the rent from 100 rupees to 500 rupees, for example. He has to go before the rent board, make an application, and that's also a process. You need to lead evidence to show as to why you are entitled to increase the rent from this amount to that amount. So all these statutory provisions were a mechanism to protect the tenant, because the government thought that at that time the landlord was in a higher bargaining power. They had more strength in bargaining, whereas the weaker tenant needed to be protected. So that was the understanding at that time, when there was a very few or limited dwelling or business premises that were available at that time.
So a question that arises, sir, when considering the Rent Act and its philosophy, as you mentioned previously as well, when this act came into force with multiple others during the regime where socialist ideology was basically predominant, you also mentioned that there was favoring towards employees being not getting fired as easily, and it's not as corporate. We see something similar relating to the Rent Act in itself, where eviction is not something that occurs easily and has to be triggered by multiple clauses.
You are absolutely right, Anuradhi. The Rent Act, now for example, if I give a premises on rent to you, and if it is governed under the Rent Act, I can't just issue you a notice and I can't evict you from the premises. If the premises falls under the Rent Act, there are very limited grounds where I can eject you. And the grounds are, for example, if there have been arrears of rent for a period of 3 months or more. Even if that is the case, the tenant is entitled to come to court when you file that action based on arrears of rent and pay that arrears of rent, and then you can't maintain that case any further. Then, for example, if the owner landlord wants or the landlady wants the premises for his or her reasonable requirement. So that has to be proved by evidence as to why the landlord or landlady wants this back. Why is it reasonably required? Then there are other provisions, like for example, if the tenant makes structural alterations, that's a ground for termination of the tenancy. If the tenant causes nuisance to adjoining buildings and residents, that's another ground for terminating the tenancy. So these are very limited grounds. Now, if you compare premises which are governed under the Rent Act and which are not governed under the Rent Act. Now, like I explained to you, all these stipulations are there to be established before you can seek an order for eviction from a competent court. Whereas premises which do not fall under the Rent Act, for example, there are two categories of lettings. One are in terms of leases. Leases are lettings for a particular period of time, say 1 year, 2 years, 5 years, and the terms and conditions are specifically described in the lease agreement between the parties, and that has to be signed by a notary and attested by 2 witnesses for it to be valid. Then the other concept is a contract of monthly tenancy, where there is no specific period of time, but it's a rolling contract of tenancy, and it can be terminated by giving a month's notice. So once you give a month's notice, then if the tenant still doesn't go, then you can file an action, and it's a straightforward application, and the court will make an order accordingly. Likewise, in a lease agreement, when the period is over, or if there's an early termination for a material breach, then that landlord or landlady or the lessor is entitled to institute action in the court based on the fact that the lease has expired or it has been terminated for cause, and seek the eviction of the tenant. So those are our straightforward procedures. But in terms of the Rent Act, you have to come in one of those specified grounds to seek ejectment of the tenant. And even if you come under the specific grounds, that alone will not grant you or allow you to seek that relief which you want. You have to still give them notice. It depends on which statutory provision you're relying on in terms of Rent Act. You have to give them notice of a period of 3 months or 6 months, which is more than the 1 month period you need to give in terms of a normal letting. And you also have to deposit money with the Commission of National Housing, and that can range from anything from 1/5 of the rent up to 250,000 rupees. So those conditions all have to be satisfied by the landlord or landlady prior to any action being instituted to eject the tenants. So those safeguards have been in place since 1972 up to date for the last 54 years. So that is why I believe that the government has thought that this is enough. There has to be a rethinking of this entire Rent Act and how the landlord and tenant relationship to be construed, and that's why they revisited it and brought this amendment or the repeal of the Rent Act into play.
Exactly. The repeal of the Rent Act is something that we have to get into further specifics of as well, relating to what exactly the changes will be made to the already existing piece of legislation. But before we move on, I want to ask you a point of opinion as well from you, sir, relating to how difficult it is for ejectment to occur and for recovery of possession for landlords. Do you believe that there is at least some sort of balance of powers when it comes to the Rent Act, or is that one of the main reasons as to why we are seeing a repeal? In your opinion,
I just did a case last week in the Supreme Court that I am appearing for the landlady, and she had given the premises about 40 years ago to the tenant, and the current tenant's grandmother was the initial tenant, then the mother became the tenant, and now the grandson. So 3 generations have lived there in the property, and there is frustration now since filing of the case, and this is not a one-off thing. There are so many other landladies and landlords who have let these kind of premises and who have not been able to obtain these premises back for generations, for decades, and even when you file action in court, the tenant will not pay any rent after you file action in court. So you're looking at just for this case to be fought in court while the tenant enjoys possession, whereas the landlady or landlord does not obtain any rent or income or damages from the property. So that's a very unfortunate situation, which is the reason I believe that the government now is trying to balance and correct.
Exactly. I want to get to the specifics relating to that as well before we move on to what changes are going to be introduced with the newly reformed legislature that is being proposed and the repeal of the Rent Act. I want to ask you about the legal routes that have been taken when it comes to tenants not paying of their rent. Now, as you mentioned, so when there is, of course, a legal dispute that has been taken to court, there is no payment of rent that occurs. But also in other situations where there is no payment from the tenant's part, how exactly does the Rent Act approach this? What kind of remedies are available for the landlords?
Right. So if a premises is governed under the Rent Act, and if a tenant does not pay rent, then you're entitled to file action in court to seek the ejection of the tenant based on the tenant violating the contract, because the contract is primarily for the owner or the landlady to provide a tenantable property, whereas the obligation of the tenant is to pay the monthly rent. So if the tenant fails to pay that, that's a violation of the contract, and the landlord or landlady is entitled to institute action for ejectment. So that provision is there. But the issue is, once you file action, the tenant will continue be in occupation during the pendency of the trial and the appeals. And I've seen cases go for 10, 15, 20 years or even more. And all this time, the tenant is in occupation of the property, enjoying the benefits, whereas the landlord cannot utilize the property. And there's frustration, understandably. And even if you get the property back after so many years, it's very hard to recover damages for the from the overstaying tenant, because he might not have that amount or to recover that amount. So that's why I think there needed to be a balance in the whole this thinking of the landlord-tenant relationship.
Yes, exactly, and that's probably why we're seeing the developments as well with the new legislation that's being proposed. We do have to speak further relating to the Protection of Occupants Bill and also the other rent and lease laws that are in the country, as opposed to the act that we have, that we're going to be discussing, the center point of today. But before we get to any of those specifics, we do have to go in for a short commercial break. You're watching Law, Land and Liberty here on Other Than a News channel. We'll be right back after this, so please stay tuned.
Hello, my name is Dhanush Gunasinghe and I am a business owner. My question is on currently on tax. How has the law changed?
Welcome back to Law, Land and Liberty. We're in conversation with Mr. Kamran Aziz, attorney at law. We were just talking about the Rent Act in Sri Lanka in comparison to the other legislations that are present for renting and leasing property in the country, as well as the recently introduced Protection of Occupants Bill. Thank you so much, sir, for the previous segment. I believe we got lots of foundational understanding into what the Rent Act is and what exactly it serves as a purpose for tenants and also landlords in the country. And we stopped off on a very contentious point, which is specifically relating to exactly why there were amendments that were necessary to this act, which is almost half a century old. I want to ask you, so relating to how exactly the currently proposed amendments are going to be, well, not amendments, but the currently proposed new legislation is going to work around the existing lapses of the Rent Act. So can you please help us understand, in comparison to the Rent Act that we have, that we're discussing currently, what exactly are the biggest features of the Protection of Occupants Bill or the other legislations that are coming forward that hope to maybe stop any of the lapses that have already been existing?
Okay. First and foremost, the Protection of Occupants Bill is in relation to occupants, and occupants are defined as people who have persons who have been in occupation for 3 months or more in respect of a particular premises. Now, occupants can be tenants, can be lessees, can be licensees. So those are the people who come under the category of occupants. The Protection of Occupants Bill essentially prevents the landlord or the lessor from discontinuing utilities like water, electricity, taking steps to forcefully or forcibly eject a tenant while being there without an order of a competent court, and doing certain acts which will compel the tenant to leave the premises in question. So those are prevented in terms of this bill, but those are the very those were also there essentially in the Rent Act as well. This protection that have been afforded to the tenants were in fact also there in the Rent Act, which is sought to be repealed. So I think the government would have thought that since the Rent Act should be repealed and they have taken this decision, there must be some protection for the tenants. So they would have thought that as a balancing mechanism, since the Rent Act will be repealed, we'll give that protection in terms of a new bill to the tenants. I think that was the understanding of the government.
Yes, and moving towards what exactly you mentioned as well, the biggest, of course, protection of occupants, be it which type of occupant, there is some sort of added coverage that's been granted. But in currently existing legislature, so apart from the Rent Act, of course, premises that don't fall within the Rent Act, what laws are currently existent in order to help protect occupants? Is there anything that we see that's consolidated into one act, or is it fragmented?
It's fragmented. I don't think it's consolidated into one act. The Rent Act was the essential act which provided protection to tenants. And this new act, the Protection of Occupants Act, I would also like to say, with your permission, that although it's good in its foundation, and I can understand where the government is coming from, I think certain provisions of the act need to be revisited for the reason that now if a landlord discontinues electricity or water, that's not condoned. We cannot accept that while there's a sitting tenant there. There are other ways and means. And then the tenant will go to court and seek orders in terms of this new law. But there's no provision in terms of this act that the tenant is required to pay his monthly monthly dues, the monthly rent to the landlord or landlady, so which should be considered before this act is passed in Parliament. Now these protections were also there in the Rent Act, but the Rent Act also had a condition that those will be granted subject to you paying the monthly dues, the monthly rent. Whereas in the Protection of Tenants Act, the recent bill which is ought to be passed does not contain such a provision. So that needs to be considered prior to passing, in my opinion, because otherwise it would also be very unfavorable to landlords who have a right to obtain the premises back, but the tenants are not paying them any money, so their monthly dues. So I think that has been thought of in a holistic manner.
Yes, and in relation to the other pieces of legislation that exist in order to consider the renting and leasing of property in Sri Lanka, specifically leases as well, that we weren't able to touch on much, do you believe that the existing provisions when it comes to leases are tallying much with the currently proposed bill? Do you think we'll see some sort of consolidation? What does it look like in that aspect?
So I believe you're adverting to the recent law, Act Number 1 of 2023.
2023,
yes. Yeah. So that I believe was a timely piece of legislation brought by the government. It provides for a faster disposal of cases where the landlord-tenant relationship is governed under a lease agreement. Now, in terms of the lease agreement, and when it's determined or when it's upon expiry, the landlord is entitled to file action to eject the tenant. Now, the tenant ordinarily, before this law came into place, tenant can fight the case, and it would take years and years to come to any fruition. But here, it's a faster process. The tenant has to deposit all arrears of rent, has to deposit utility payments, and has to also pay damages up to a period of 1 year from the date of him being allowed to defend the action, so that those protections are there for the landlord, which is not there previously. So I think it's a good piece of legislation, but also I'm not saying it's a perfect kind of legislation, but it's a timely piece of legislation which needs to be revisited again in respect of certain things, because even if a tenant contests the case after the landlord filing it on the basis that the lease agreement has expired or has been determined before, the tenant still occupies. Now, once the decree nisi is issued, that's a conditional order is issued, the tenant can contest the case from that time. So it might take from anywhere between 2 years to 5 years, because there's the essential fact of leading evidence to prove your respective cases. So that might take some time, whereas the requirement of the tenant is to only deposit 1 year. So it might, in economic sense, it might also be advantages to the tenants to deposit the 1 year and stay for the next 5 or so years. So that has to be looked at properly again, in my view.
Now, sir, a question that arises among the general populace, of course, is when there is considerations done with previous parties and there may not be a written agreement for rent. How exactly does Sri Lankan law approach this? What kind of mechanisms are in place in order to maybe prevent this kind of issue happening, or if it has already taken place, what exactly are the fallbacks or the safeguards?
So I would say the majority of the tenancy contracts between the landlord and the tenant are unwritten. And that poses a danger not only to the landlord but also to the tenant, because it would always be favorable if both parties know their rights and duties and responsibilities and they put that into writing, so that there cannot be any room for interpretation between the parties. For example, if there's an oral agreements are also valid in terms of our law, and there's an oral letting agreement, and based on that there's a contract of monthly tenancy. It would be a matter of who is right between the two as to the amount of payment, monthly the duration of the period, or the monthly rental due and the security deposits. Those matters are contentious between the parties. So it's always more advisable to put it in writing and have a lease agreement for a particular period of time, setting out your rights and duties.
Yes, and relating to lease agreements as well, sir, before we get to the specifics relating to the rest of the Protection of Occupants Bill, I want to ask you on the Lease Act, the 2023 Act that we have, what is the process that has been set in place for the ejection of tenants, occupants, and also do you believe that the process that has been set out in the 2023 Act is concise and actually all-encompassing, or do you believe that the new upcoming Protection of Occupants Bill will have something to add in relation to that?
See, the Act number 1 of 2023 is a step in the right direction. There's no doubt about it. It is a good piece of legislation which also tries to even the playing field and gives a little bit more protection to lessors in respect of lease agreements. Now, when a lease agreement has expired or is terminated due to any reason that is provided for in terms of it, the landlord or the lessor is entitled to file action to eject the tenant. Now, ordinarily that it might take years for the conclusion of the case, but this piece of legislation specifically requires that the entire procedure should be under the summary law, which is a quicker, faster, efficient law. Now, upon the landlord filing the case, a decree nisi is issued if there is sufficient grounds, and then the tenant has to come to court and establish a prima facie defense. Now, if there's no prima facie defense, the conditional law or the decree nisi is made absolute, and that's an order for ejectment, and the tenant is ejected from the property immediately. So that takes a very short time. Now, in the event the tenant comes to court and the court determines that there's a case to be looked into, even if that's the case, the court must direct the tenant to deposit security, like I mentioned before. And that security is not only for the next 1 year, but also all arrears of rent plus the utility bills. So those have to be deposited in court prior to him proceeding with the case. So it's a quicker mechanism compared to what it was previously. So that's a step in the right direction. But in terms of Section 5 of the Act, it sets out what the landlord or the lessor is entitled to. It says arrears of rent, liquidated damages, then utility bills to be recovered, all that. But it doesn't provide in writing or specifically that the lessor is entitled to seek an order to stop the business if it is a business premises of the tenant concerned. Now, that is a very now in terms of the common law, that's something that is used frequently as a means of fast tracking this entire process. Now, if the tenant is operating a business from the business premises concerned, and the landlord has terminated the agreement for whatever reason, if the tenant is allowed to continue his business, he will very happily proceed to do so for years on end. Now, if the business is stopped, which is permitted in our law, on the basis of a wrongdoer principle, a wrongdoer cannot obtain the benefit of his own wrongdoing. So when he's in unlawful and forcible occupation after notice has been sent, he cannot reap the benefits of his own wrongdoing, and therefore the courts have decided that if he's doing that business, it should be stopped. If that happens, that will fast track the entire procedure to eject that particular tenant. But that is not specifically mentioned in this Act number 1 of 2023. So maybe that needs to be maybe by an amendment or some other mechanism, because it's there in the common law, that is there in black and white. So there's a confusion when it comes to certain judges, how they construe this Act, whether that can be applied here because it specifically doesn't provide for it, or is it supplementary to what is already here. So that's a matter to be decided by higher courts. But so I would say that this is a very good Act and a timely Act. I think there are certain modifications that could be made to better enhance its actual intention.
Yes, and a question that could be a little bit contentious, but of course to get your take on it as well, sir, do you believe that the already existing legislation, and now that the Rent Act is also going to be repealed, there is a shift of the balance of power which favors landlords more than tenants and occupants. Do you think that the upcoming legislature can help to balance that out, or will there be a problem in that sense with disputes moving forward?
I think that the Act number 1 of 2023 was that kind of legislation which sought to balance the scales. From the Rent Act 54 years down the line, 52 years by the time this Act came into operation, it sought to balance the scales. But I think that if the Rent Act is going to be repealed, there has to be certain protections given to the tenant. It can't be a one-sided story. I will not advocate for that at all. I will always advocate that the landlord is entitled to his property once a valid notice is given, and if the tenant is in unlawful and forcible occupation, then by all means there must be mechanisms to stop that and recover possession immediately. But during a valid lease agreement or a valid tenancy agreement, the tenant also must be afforded rights and protection, which I think that this Act is trying to do. But it should also balance the other way by having payment during that time by the tenant to the landlord, like I discussed earlier. Otherwise, it will also be construed as a one-way stream.
Exactly. And to get to the specifics relating to how exactly the court will approach these bills separately and the actions within it, and also the balancing of what happens when the Rent Act is repealed is something I want to get into specifically. But we do have to take a short commercial break. You're watching Law, Land and Liberty here on Other Derana News Channel. We'll be right back with the final segment where we'll be discussing the specifics relating to what occurs in the aftermath of the introduction of this new bill and the postponement or the repeal of the Rent Act. So please stay tuned.
Hello, my name is Shihani Kalwarachi. I'm a psychology student. My question is, on the future, how will these changes play out in court?
Welcome back to Law, Land and Liberty. We're in our final segment in conversation with Mr. Kamran, Aziz, attorney at law, speaking on the Rent Act and other related legislatures in this country. Thank you so much for the previous two segments. I believe we got as much insight as possible with the short amount of time that we have to discuss multiple works of legislature. But a question that arose before we get to the specifics on to the aftermath of what we can expect to moving forward with the developments that we're seeing right now is how exactly the courts balance rights and justice being prevailed through each of these different acts that we have in place. Do you believe that the current system that's in place that tries to balance whatever wrongfulness that has occurred on either end is effective, or does the provisions within each act prevent proper justice from being given? Because as you mentioned, there is a favoration almost towards tenants within the Rent Act, but also the 2023 Act number 1 of 2023 is trying to balance that. Is there a proper balance that has been achieved?
See, the thing is, the courts merely follow the law. So there's no favoration by the courts when it comes to following these pieces of legislation. They just merely follow the law. There's no favoration at all. It's the parliament which passes these pieces of legislation which has created this situation right now. So from the Rent Act in 1972 to the repeal of the Rent Act now, and before that the Act number 1 of 2023 and the protection of occupants bills. So these are recent, the last three legislations, the repeal of the Rent Act, Act number 1 of 2023 and the protection of tenants, it's I think a mechanism to safeguard both the landlord and the tenant. That was, I think, the idea behind these acts. Now, the reason for the repeal of the Rent Act is very clear. Now, there was unequal bargaining power at that time, and they wanted to balance the scales. Now, you couldn't just, there was a specific, we discussed, a specific mechanism to eject a tenant. You can't just you can't just issue a notice and get the premises back. And it has to come within one of those few grounds. So, that has changed now, which I hopefully it will change now. It is, the Gazette was published by Parliament in September. It was tabled in Parliament in January. It was put to an expert committee soon thereafter, but there was a lot of public observations which are submitted to Parliament, and now time has been granted, I believe, until the 4th of March for the public to provide their observations to this expert committee, and then the Parliament will decide, or the government will decide, how to proceed with that bill. But I believe that the repeal of the Rent Act is timely. It's a very good initiative. And I think as long as the Protection of Occupants Bill will be passed in Parliament, subject to certain modifications like we discussed, I think that would balance and protect the interests of both the landlord and the tenant.
What exactly can we expect moving forward following the repeal of the Rent Act now, as you mentioned, sir, obviously our new legislature has to come into force as well.
Yes.
Is there going to be lapses that we can expect moving forward? What is it?
So once the Rent Act is repealed, you can't, no landlord can institute action in respect of a premises that came under the Rent Act for a period of 1 year after that. So that protection is also there, and that is given to a tenant. For a period of 1 year, you can't do that. And also, you can't seek any increases in rent for a period of 1 year. So those protections have been given by this Act to the tenants. So that is there, in addition to the Protection of Occupants Bill as well.
So that means there wouldn't be any sort of mass upheaval. There's obviously going to be any for whatever preparations to take place.
Yes, it's not sudden. It's not something that is going to come out of the blue. So the tenants will obviously be prepared for this.
When it comes to the practical application, now being an individual that practices in the courts and sees these kinds of disputes on the daily, are you experiencing as a legal professional increases in disputes arising relating to the Rent Act or even Act number 1 of 2023? What is it looking like right now on the ground?
I have appeared for tenants as well as landlords, both in respect to the Rent Act and both in respect of Act number 1 of 2023. So I can speak for both sides, and I think right now I think it's the playing field is a bit level compared to what it was. But I think going forward, I think subject to those modifications, it would be, I think, helpful if those modifications are also incorporated into those laws to make it a bit more better in the long run.
Yes, exactly. Now we are running out of time, but I want to ask you one of the final few questions. When it comes to advice that landlords would have now, specifically under Act number 1 of 2023 as well, what are some of the biggest mistakes that you've seen when it comes to the practicing of this Act and the rights that landlords attempt to exercise with their properties? Is there anything specific you can point out?
Yes, now if you go to PETA has a large business tenant market, and it's basically I would say 70% based on key money, the concept of key money. You pay an upfront payment and you pay a very little small monthly rent to the landlord. And this has been going on, this has been the practice in PETA for the longest time, especially in that area. Now there's no written agreement, and invariably there are disputes between the parties. So I would always recommend both tenants as well as landlords to enter and put whatever their requirements into a specific lease agreement, so that both parties know their rights, duties and obligations, and they can't maneuver themselves out of it. And the expectation is there as to how long you want to be there. Because certain tenants think that they can live on and on and on in a tenanted property. That mindset should not be there. That should be taken away. The tenant sometimes feels that if they've been there for a particular period, they're actually the owners of the property, and the landlord, in trying to get it back, is very frustrating. So I've seen that also happening. I also seen tenants who have right to be in occupation being ejected from their property illegally, and it takes years for them to come back after filing an action to come back, and by that time they have lost all their resources, and that's very unfavorable to them. So these kinds of legislations that are being brought into play, I think, reduce that prejudice that is caused to both sides.
Yes. A practical question relating to multiple acts already existing in order to govern one singular area is, will there be any sorts of mix-ups or confusions in any sort relating to how the law is applied over these different varying acts? Do you think practically there is a possibility, sir, or do you think it's completely not?
There's always a possibility. I maybe perhaps in respect of lease agreements, certain provisions of the Protection of Occupants Bill could be incorporated into into Act number 1 of 2023, like it was there in the Rent Act. So those things can be thought of in the future. But I think we are going the right direction. We just need to fine tune our.
Yes, exactly. When it comes to the fine-tuning approach as well, just a question of curiosity before we have to end off. When it comes to the Protection of Occupants Bill, you previously mentioned that occupants have, the word occupant covers a varying number of positions. Can you just give us a little bit more specificity relating to what exactly, which type of individual or which position the Protection of Occupants?
Right, so premises that has been let to a party. It can be a tenant on a contract of monthly tenancy. It can be a lessee on a lease agreement, or it can be a licensee. A person who has been in that property for a period of 3 months or more is deemed as an occupant, and that occupant has rights to continue in occupation until that person is ejected from an order of a competent court. So you can't go and arbitrarily knock off your electricity, water, try to compel that person from leaving the premises or eject him forcefully. So those are prevented in terms of this act, which is good.
Apart from the good, as you mentioned, there were certain lapses that you said that we should be addressing before this bill takes full effect. Can you walk us through a few of the key issues that you see, apart from the ones that you mentioned previously as well, if we can consolidate it to see exactly where the key errors
Yes.
can be?
So, like the tenant has rights, the landlord or landlady must also have rights. So you can't expect the tenant to be restored to possession or to provide him with electricity and water while the tenant is not paying the monthly rent. Now, this was adverted to by 2 previous justice ministers, Mr. Ali Sabri as well as Professor G.L. Preris. They also provided their expert observations on this particular aspect as to why should the landlord be made to do these things when the tenant fails to fulfill his obligations. So these must be addressed as well in this act. Otherwise, it seems like a one-way system where the tenant is protected, whereas the landlord's rights are not considered. So I think both these things have to be taken into at the same time.
Yes. We have some extra time, and so I would like to ask you this question specifically relating to inheritance. Now, so with the applications under the Rent Act and also Act number 1 of 2023, how exactly does changing of ownership get addressed in these legislatures? Is there anything alluded to it in the upcoming acts? What does it look like?
Okay, so in terms of the Rent Act, which is going to be repealed hopefully, Section 36 stipulates that if a member of the family, spouse, child, and who was living in the property at the time the initial tenant dies, in terms of the law, becomes a tenant. Likewise, the business premises are also just like that. So there's a flow as to who the tenant is and specifically provided for in the Rent Act, which is going to be repealed. But whereas it comes to a contract of monthly tenancy, once the tenant dies, and that same protection is not available, so the tenancy dies with the tenant.
So, as we can see with the upcoming legislature also, that kind of context does not change. That is just as it is, how we have already expected it to be since prior as well.
Yes.
Moving on, sir, now looking ahead, what we can expect to see as changes in development, or maybe with your recommendations, what you have seen. As you mentioned, there are certain changes that would be preferably made to existing pieces of legislation. Can you walk us through some of the key areas that we should be addressing first and foremost with the upcoming bill, the Protection of Occupants Bill, as opposed to, of course, the already existing and already enacted Act number 1 of 2023? What are the key areas that maybe lawmakers should be looking at right now in order to ensure that it is a more holistic approach to renting and protection of occupants?
Okay, so like I just mentioned previously, if we can also have certain provisions
apart from how exactly landlords and landladies can be protected, is there anything else on the other end that needs to be approached, or do you think it is already completely consisting of all the necessary qualities?
Okay, so we can also have some thought on the deposit, the security deposit that is given at the commencement of the tenancy. So there must be a mechanism that it should be paid as soon as the tenant leaves. So and at the time the tenant leaves, sometimes the landlord reduces electricity bills, arrears of rent, so on and so forth, which sometimes the landlord is not entitled to do so. So I think there must be some specific guidelines as to how, on what basis those can be deducted and when the security deposit should be paid back. I think that's all up in the air at the moment, and sometimes the tenants don't even receive the security deposit or have a reduced security deposit paid back once the landlord obtains vacant possession of the premises.
Exactly. Relating to that as well, so now with your experience as to how the courts approach this, as you mentioned, of course the courts will follow the legislation that's already put in front of them, and that is how it has been done. But have you seen recently if there's any landmark cases that you can recall at any point relating to occupancy and maybe the recovery of possession of premises, where it shows that it is a level playing field and it is not that occupants are now disadvantaged with the recently introduced act?
See, I did a case, I'm still doing that case, where the decree nisi was not made absolute and the tenant was granted permission to file and defend the action. And the court was very just and fair and said, look here, now if you're contesting all these facts, you need to deposit this amount of money in court for the next year and contest the case. So that was done. I think the courts are balancing it very well and adhering to the law perfectly. It's just that the Parliament needs to consider that without just having it on for 1 year, whereas the cases take sometimes 3-4 years, to increasing that deposit or making it essential or incumbent on the tenant or the lessee to make another deposit until that case is over.
Yes. We do have to end off. We have a little bit more time. The key pieces of advice that you can give, not just to landlords but also to tenants relating to this area of law. It doesn't have to be relating to the upcoming act, but on the presently existing grounds that we have. If you can just leave our viewers with some advice relating to what exactly the key things that one should keep in mind when renting or leasing or being an occupant of a property.
Okay, so my first piece of advice is always try to enter into a lease agreement. Your rights are protected and both parties know what their obligations are, and there is no room for maneuvering from that. Then I would also always advise that even some parties do not wish to register their lease agreements. I think that's a bad thing. I think all leases must be registered because if it's not registered and it's not executed by a notary and 2 witnesses, it's not enforceable in court. You can throw that piece into the garbage bin. So I think that lease agreement attested by a notary and 2 witnesses as required by law should be the norm and not the exception. And I think both parties, the tenant and the landlord, must do this to protect their own interests and the interests of the property, and that should be the norm.
Yes, I think sound piece of advice to unfortunately have to end off on this discussion on. Thank you so much, Mr. Kamran, Aziz, attorney at law. Thank you so much for taking the time to come to the studio and to help us understand this vast area.
Thank you, Anuradhi. Thank you.
All right, well, we leave you tonight with the words of Muhammad Ali. Service to others is the rent you pay for your room here on earth. That's all we have for you on Law, Land and Liberty. If you had missed any of our programs, you can always rewatch by catching us on our YouTube page. And please do share your thoughts and feedback with us through email at feedback.ad24english@derana.lk or by WhatsApp at 076 805 7933. Thank you very much for watching. Have a great night.